mislead people for some other purpose.
Damn right, there's a lot of misleading going on, and I think said person is one of them. What do you think? Leave your comments below. Check out Mr. Geist.
Devils do lurk in details, and that's why the scrutiny of this committee is so important. But what's at stake here is we need what is set out in Bill C10 with all its provisions and all its protections, and we urge the government to pass this legislation as quickly as possible.
Theories that some have floated and that Minister Guilbeault disappointingly retweeted. As I'm sure you're aware, I've been quite critical of Bill C10. I'd like to reiterate that criticism of the bill is not criticism of public support for culture, nor of regulation of technology companies. And I think that there are ways to ensure money for creator programs this year, not in 5 years like in this bill. Further, I'm puzzled and discouraged by the lack of interest in Bill C11, which would move towards modernizing Canada's privacy rules to help address concerns about how these companies collect and use our data. The bill would also mandate algorithmic transparency, which is much needed and far different from government-mandated algorithmic outcomes. There is simply no debating that by removing Section 4.1, the bill now applies to user-generated content, since all audiovisual content is treated as a program under the Act. You've heard experts say that, and department officials say that. The attempts to deflect from that simple reality by pointing to Section 2.1 to argue that users are not regulated is deceptive and does not speak to the issue of regulating the content of users.
The Globe and Mail called the minister's performance amateur hour on C10. Open Media has said the Prime Minister and this minister have lost the plot with this law. Michael Geist, the leading expert, said Bill C10 represents an unconscionable attack on free expression.
That no one, literally no other country, uses broadcast regulation to regulate user-generated content in this way. There's good reasons that all other countries reject this approach. It's not that they don't love their creators or that they want to avoid regulating internet companies. It's that regulating user-generated content in this manner is entirely unworkable, a risk to net neutrality, and a threat to freedom of expression. For example, the European Union, which isn't shy about regulation, distinguishes between streaming services such as Netflix and video sharing services such as TikTok or YouTube. From a charter perspective, the statement issued by Justice last week simply does not contain analysis or discussion about how the regulation of user-generated content as a program intersects with the Charter. There is no evidence that there is a discoverability problem with user-generated content. Ms. Yale's panel, which notably appears to have lost its unanimity, recommended discoverability but cited no relevant evidence to support claims there is an issue with user-generated content. Third, the objective of making YouTube pay some additional amount to support music creation isn't enough to save the impairment of free speech rights either. And I'm not alone on that. Canadian heritage officials thought so too in a memo they wrote to the minister.
This committee has been heavily placed with people who are for this bill, broadcasters, not YouTubers, or people that are concerned about what they can do behind the scenes. And that's the big fear. Leave your comments